delay, but usually I do start about 5 minutes late, so we're right on schedule. But I panicked, I won't lie, because I couldn't get my microphone to unmute and I couldn't get my video to turn on. So I'm happy that that was fixed. So my name is Heidi Klippel, and I'm going to talk to you guys today about estate planning. And estate planning handout was emailed to everybody, and Vanya usually will post the handout on the chat. I unfortunately don't know how to do that, but she's so good about doing that for us. But let's go ahead and get started. So today we're going to talk about estate planning and what that is. Estate planning is typically going to be your trust, will, durable power of attorney, and healthcare directive. Really, there's two parts to an estate plan. You've got your financial side to your estate plan, and then you have your medical side to your estate plan. And the financial side is comprised of your durable power of attorney, your trust, and your will. And then your healthcare directive is basically on its own. So why don't we talk first about your healthcare directive? Really, the healthcare directive is something that once you turn 18 years of age, it's something that everybody needs. The purpose of a medical directive is to nominate somebody that you know and trust that can step into, oh, you don't have the handout, it wasn't sent to you. Let me see. Nobody got the handout. Okay, that's just great. Let me let Kirsten know that nobody got the handout. No one got our presentation. So I just let my paralegal know. Hopefully she can get it sent to everybody. Sorry about that. Usually things are handled more efficiently. So sorry. So when you have a healthcare directive, you're basically going to nominate the person that you trust to be your medical advocate when your doctor doesn't feel that you can make your own medical decisions for yourself. And once you're 18 years of age or older, that is when you need this legal document. And it's a very important document to have, because if you remember that lady whose name was Terry Schiavo, she was that young woman who in Florida was involved in an accident. And when she was on life support, there was a case that found its way all the way to the United States Supreme Court, because when she was on life support, her husband did not believe in his heart of hearts that his wife would want to be on continued life support because she was in a permanent vegetative state, whereas her parents, for religious reasons, believed that it was best to keep her on continued life support. So these three very well-intentioned people spent a lot of time and money basically fighting over what she would want, the continuation of life support or the withdrawal of life support. And it wasn't until an old college roommate came forward and gave testimony that they were at a bar when she was in college, that she had made a comment during this conversation back in college that if she was in a coma, that she wouldn't want to be on life support in that situation. And based on those findings, the life support was ultimately withdrawn. So when you have a medical directive, to me, that is one of the most loving documents in your estate plan, because most of us don't really spend the time with our loved ones to talk about how we feel about those really important end of life decisions and our ideas about quality of life, because that does look very different to all of us. And in that healthcare directive, we also include very important information and decisions about whether we want to be buried or cremated. And in California, in the year 2027, a new option of burial is going to be legal in our state, and that's called composting. And that is going to be a new option as far as how you want your body to be handled at the time of your death. And that's something, if you haven't heard of composting, it's legal in Nevada now, and it's going to be legal in our state in 2 more years. So having that decision made ahead of time, and sometimes even letting your family know that you don't have a preference as to whether your body is buried or cremated or even being composted, is a very loving thing to let your family know, because not having a preference is making a decision so that your family knows that they can make the decision, and that takes the burden off of your family during an already difficult and emotional time. So making that decision or telling them that you don't have a preference in your healthcare directive can be one less thing that your family has to decide during a very difficult and emotional time. So in that healthcare directive, you're going to nominate people that you trust to be your medical advocate for you when you lack capacity and can't make those medical decisions. You're going to include your preference about how you want your body to be handled at the time of your death, whether you want it to be buried, cremated, or composted in 2027. You're also going to include your preference about life support. And that is an isolated situation that anticipates that your physician, two physicians, have made a medical diagnosis that life support is prolonging an inevitable death. And oftentimes people will give their loved ones the ability to withdraw that life support immediately because they've already made the decision that they don't want to be on that continued life support. Sometimes people will say that they want to give that decision to their loved ones to decide at that time.
All that ding, ding, ding.
The Heidi.
Other times people might say that they want to be on life support for a minimum of 3 days,
Estate planning.
7 days before the.
Just once I read Jeff's whole will thing, and it's kind of confusing because we're considered one entity. You know, Julie.
James, Lynn, can you mute yourself, please?
Sorry.
And then the other thing that you can decide in your healthcare directive is whether or not you want to be an organ donor. And with modern technology, there's a lot of amazing things that they can do with our bodies now, whether it's giving your skin to burn victims, whether it's giving your organs and tissues to save a life, whether it's giving your body parts to medical research and science, or whether it's giving your cadaver to a medical, to a university to be used for medical students and for science. Like the FBI has their Tennessee program that they use bodies and cadavers for there for experimentation. And sometimes people choose not to be a cadaver, choose not to be an organ donor for any purpose, which is also perfectly fine. So when you take the time to put this medical directive in place, it is the one document that has language within it that says that a copy of that document will be treated like an original. So my advice to clients is to give a copy of that healthcare directive to the people that you name in it. And that's because when your loved ones have a copy of that healthcare directive, if there is a medical emergency, by them having a copy of it, they can get it to the hospital, and then the hospital will treat that copy like an original so that the people that you nominate within it will have the legal authority to start advocating for you immediately, which is very important when it comes to making life and death decisions. I also encourage clients when it comes to that healthcare directive to take a copy of their medical insurance card and to copy it front and back and to attach it to their healthcare directive, and to keep a copy of that directive in the glove compartment of their car. Because oftentimes, sadly, if we are going to get into an accident, it's likely going to happen on the freeway or while we're driving the car. And emergency personnel will check the glove compartment to look for your license and registration to try to identify who you are. So having that healthcare directive in the glove compartment of your car is a very handy and useful place to keep a copy of it. And also when you travel, it's a good idea to keep a copy of your healthcare directive in your suitcase. And then when you check into your hotel or to your Airbnb or Vrbo, I also recommend keeping a copy of that healthcare directive in plain sight, because when you travel, oftentimes the only thing that a hotel knows about you is your phone number, which isn't going to be helpful if you're the one who's incapacitated, and they know your credit card information. But if you have your healthcare directive in your hotel room with your loved one's phone numbers and emergency contact information, which is attached to that document, then if sadly there was a medical emergency, now the hotel can actually start calling your loved ones and letting them know that there has been an emergency. And that is going to be a very important thing, because otherwise, when you travel, if you were sadly to have some kind of an emergency, the hotel doesn't know anything about you other than your phone number and your credit card information. So when you create this estate plan, for all the reasons that we just talked about, this healthcare directive is a very important document, because one, it's going to prevent very well-intentioned people from having to go through a court battle when they may not agree on something like life support. So it's better for you to make those important decisions in this document than to have your loved ones having to go through a court process to have to make that decision when they don't always agree. And then during this already difficult and emotional time when your health is failing and your family is gathering, having this healthcare directive is like a roadmap where you're providing them guidance about your wishes as far as life support, organ donation, and your burial preference, which can be a relief and eases so many burdens. And I hear from so many clients just how much having that healthcare directive just gave them so much peace. So that is such an important document to have. And then your three financial documents in an estate plan are your durable power of attorney for financial affairs, your trust, and your will. So when you create a durable power of attorney for financial affairs, that's a really important document, because it's similar in that if you were to lose capacity, you're giving somebody your legal permission to step into your financial shoes and to deal with all of your finances that are titled in your individual name. So once a person turns 18, they would want to have a durable power of attorney, because without one, if I were driving my car and if I were hit by a drunk driver, even though I'm legally married, if it was April 15th and time to file our tax return, if I was hit by a drunk driver and in the hospital incapacitated, my husband can't legally just sign my name on our state and federal income tax return. So if I was incapacitated and if it was time to file our taxes, he would have to go through a court process called a conservatorship, where he would have to petition the San Diego probate court to become my financial conservator, to have the court's permission to basically take away my financial constitutional rights to be able to sign my name on our tax returns. And it's something that understandably a lot of us take for granted, that at any time any of us could lose our capacity, because it's not something that's planned, it's not something that's expected, it's something that could be us just getting in our car and driving down the street to the store, or having a situation where, you know, there could be a medical emergency. So when you have a durable power of attorney, you're picking somebody who you trust to step into your shoes to manage your finances. So you're going to want to think about who's good with managing their own finances. And oftentimes people will say, is it an inherent conflict if I pick my spouse or my children or a family member? And to me, those are the logical people to name. You don't have to have a professional corporate trustee or a private fiduciary or an attorney step into that role. And in my opinion, I think you're better not to have people like that in that role, because people like that are expensive, it's impersonal, they don't know anything about you. Whereas who better to take care of you and your finances than the people in your immediate circle that know about you, that know about how you invest your money, how you spend your money, save your money, than your immediate family. But in every situation, there's always exceptions to the rules. And sometimes naming children as trustees or as durable powers of attorney doesn't work for everybody, because if you have adult children who have an estranged relationship or who don't trust each other, or if there's issues with gambling or substance abuse or any other type of an issue, because there's a myriad of them, it doesn't always work to put adult children in that financial role, and that's okay. Sometimes people will look to their parents to be their successor trustee or durable power of attorney, or their brothers or sisters. Other times people might look to a close beloved friend or even a neighbor. And then sometimes people will look to a professional because they want to keep their affairs private, or they don't want to burden their loved ones, or they just trust the experience and expertise of a professional who's licensed and bonded and does this every day. And they'd rather have a professional step in and do their financials versus have it be a family member or a friend. But when you create a durable power of attorney for financial affairs, it's important to understand that you're giving powers over assets titled in your individual name, such as retirement accounts, income taxes, vehicles, life insurance, annuities, lawsuits, litigation. Because when you create a trust, there's two specific types of assets that go into a trust. And the reason why there's two specific types of assets is because these two assets are the types of assets that trigger probate in California. And I just want to say before we talk about this, that all states do have different laws. So when I'm talking about our state laws, I'm specifically talking about California. A lot of our neighboring states have similar laws to our state laws, but all states do have different estate planning laws. So in the state of California, when we pass away, if you own real property and if it's not titled in a trust at the time of your death, that will trigger probate as to that asset. And California just enacted a new law that goes into effect in April that if your primary residence is not in a trust, and if the value of your primary residence is under a threshold, which this is a new law, so I'm not sure if it's $700,000 or $750,000, but it has to be your primary residence. It can't be a rental property or a commercial building. Then that real property will still go through a probate, but it's a quicker probate, and the normal statutory fees of probate don't trigger. And I'll talk more about what all that means in a minute. But normally right now, because we're still in March, if you own real property that's not titled in a trust, and when all of the owners of that property pass away, that will always trigger probate as to that asset in the state of California. And that's part of why so many people that are homeowners have trusts, because they know that when you create a trust and when you prepare a deed that puts that house into that trust, that house will no longer trigger that court process called probate. And there's one other thing in California that triggers probate in our state, and I call this a magic number. And that is that every state has a magic number, which means that if I have assets titled in my name, and if I don't have a living beneficiary to inherit that asset, you have to find all assets like that and add them together. And if the total aggregate number of all of those assets exceeds our state's magic number, then those assets will trigger probate. And what an example of that would be if I had a checking account titled in my name, and if I didn't have my husband, my kids, or my trust as a pay on death beneficiary, then you have to find that asset plus anyone like that. And if when you add those assets together, they exceed California's magic number, then those assets would trigger probate. Our state's magic number is $184,500. And for that reason, when you create a trust, you're also going to put your taxable assets into that trust. And by taxable assets, we're talking about checking accounts, savings accounts, CD accounts, money market accounts, taxable investment accounts, corporate ownership interest, your member interest of an LLC, your stock interest in an S corporation, your stock interest in a C corporation, yachts, motorized vehicles, if you have timeshare interests, vacation homes, rental properties, and any other asset that's not a retirement asset or an annuity, because those are the two exceptions to the rule. So when you create this trust, a trust metaphorically is like a bucket, for lack of a better metaphor. And when you create this trust, you put the real property into it, you put the taxable assets into it. And as long as at the time of your death, those assets are titled into the trust or name the trust as the pay on death beneficiary, then those assets will avoid probate when you pass away. And that's why so many people in California have trusts, is because they want to avoid probate. And part of why we want to avoid probate in our state is because the fees are statutory, which statutory is a fancy word for saying that our fees in California are predetermined by law. And an example of our fee structure is they say the average home right now in San Diego County is worth on average $1.2 million. They say the average family in San Diego County has $700,000 of assets. So if that estate went through probate in our county, the probate fee on that estate is $73,000, which is a lot of money. So that's part of why so many people in our state do these estate plans, because when you create this trust and when you do a deed that transfers the real property into the trust, and when you update title to your bank accounts, checking accounts, investment accounts to either have them titled in the trust, or if you keep those assets titled in your name, but you have the trust as the pay on death beneficiary of those assets, as long as those assets stay titled that way at the time of your death, then those assets will avoid probate, which in essence is putting $73,000 more into your loved one's inheritance bucket, because we've just avoided that unnecessary court process called probate. And that's really important, because the other downside to probate is it is also a public process. So a lot of people don't realize that if I died yesterday, to not jinx anything, and if my estate went through probate, and assume that my husband also died with me, now my two minor children and everything about them is part of that public process. So any person, good, bad, pedophile, whatever that might look like, gross, but I use that on purpose because it's true, they can go pull our file and see where my kids are living, how old they are, their date of birth, their social security number, how much money they're inheriting. All of that information is part of that public process. And the reason all of that is public is because the state of California wants to make sure that all of that information is public, so that if there's any creditors out there that we might owe money to, that all of our information is readily available, so they can make sure that we have liquidity in our estate, so that the creditor can decide whether they want to put a claim against our estate. And that's part of why everything is accessible. But the downside to that is, in today's modern world of identity fraud, identity theft, and sadly, when you've got minor children, none of their rights are protected, because the creditor's interest, it basically is the priority. So when you have an estate plan and when everything is properly titled at the time of your death, you not only avoid that public process and save all that money, but you also give your beneficiaries the benefit of keeping all that information private, which to me is almost more important than all those other things that we just talked about. So that's part of why, in my opinion, probate is such an antiquated process, because what probably didn't used to be such a bad thing, by having that information be public, in today's modern world, having all that information being public is not ideal. And those are older laws. So that's part of why I keep mentioning when you die and how assets are titled, because sometimes what happens is when you go to your estate planning attorney, and when they put this trust in place, and when they do the deed and they put your house into your trust, sometimes what can happen is, in the future, when the mortgage rates go down, people will refinance their home, and unbeknownst to them, a mortgage broker or lender will then take the house out of the trust as part of that refinance process. And now you have someone who has this trust, but now their house is no longer titled in the trust, but they have no idea. So when you pass away, if you have a trust, but your house is no longer titled in the trust, now you have a situation where the house will trigger probate. And that's the purpose of your will. So when you have a trust, you have a very special kind of a will called a pour over will. And the purpose of a pour over will is to say that when you pass away, if you have assets titled in your individual name that doesn't have a beneficiary attached to it, those assets are going to pour over into the trust and be given to the beneficiaries of your trust. Ideally, in a perfect world, if you've done everything properly, the only asset that we really want the will to have to deal with are your vehicles, because you can't really attach a beneficiary to your cars. So as long as your cars and total aggregate value is under $184,500, we don't have a probate. But in my last example, if we refinance the house and unbeknownst to the owner, the house is now outside of the trust, because we have real property plus a car that's outside of the trust, that pour over will is gonna take those two assets through probate, and then they're gonna pour over into the trust and be titled into the trust at the close of the probate. But because we have real property outside of a trust, it's important to understand that even when you have a trust, you can still have a probate, because now we have that real property that's not titled in a trust, even though we have a trust. But because the real property is outside of the trust, that will trigger that probate as to that asset in that vehicle. And it's the pour over will that will pour those two assets back over into the trust. So when you create this estate plan, you've got the durable power of attorney. That's very important, because that's how we avoid a court process called a conservatorship. Because if you remember, a conservatorship is a legal process that occurs when you lose capacity and you don't have a durable power of attorney in place, naming who you trust to make your financial decisions. So when you have a durable power of attorney in place, we avoid that unnecessary court process, because now you have a legal document in place saying who you trust. And because you made that document while you had capacity, the courts will give that legal document deference, so that we don't have to go through that court process called a conservatorship. And the people that you chose while you have capacity, you are nominating them, which is an important thing to know also. So when you nominate your loved ones to be your durable power of attorney, they do have the ability to accept that nomination, or they can decline that nomination. And there's also the flexibility of resignation built into these documents. So if your loved one decides when the time comes and you lose capacity, that they're maybe not in the best place to be your financial advocate, they can always decline the nomination, in which case it's always good to nominate at least 2 to 3, if not 4 people to be these financial advocates for you. Because even though you're nominating these individuals, they do have the flexibility under our laws to accept or to decline that nomination. And if somebody declines, that's why it's always good that you've got the backup. And if somebody who has accepted that nomination, if they need to step down and resign, it's always good that you have another backup to the person listed. So anytime you create these estate planning documents, you're always going to nominate a first choice, second choice, and third choice. And it's always good to know that these individuals do have the flexibility of accepting or declining, and they also have the ability of resigning at any time. And when it comes to paying these individuals are normally not paid while you're living, because the idea is while you're alive, we want to conserve your monies to make sure there's sufficient monies to pay for your care, because we want to preserve the estate to make sure that you have a roof over your head and you have proper medical care. But then once you pass away, that's when this trust becomes irrevocable. And then that is when the trustee is entitled to reasonable compensation. And reasonable compensation in California is deemed to be 1% of the net worth of assets that are titled in the trust. And the trustee has the ability to accept compensation, or they can waive it. Legally, they can't pay themselves compensation until after they've administered your trust, which occurs at the end of the process. A lot of times my clients will say, oh, I don't need to get paid. I'm happy to do this for free. And then I'll explain to them that they can't legally pay themselves until they've completed the process. And then I suggest, why don't they just make the decision once they're done with the work? Because sometimes trusts are difficult to administer, whether it's because of the assets that are involved, and with all due respect, sometimes it's because of the beneficiaries that are involved. But when you do pay yourself trustee compensation because you're being paid for a job, it is taxable to you as income. So that is money that you do pay taxes on, and you do report it on your income tax return. So, and sometimes people will say, I don't really want to pay a full 1%. That seems like a lot of money based on my net worth. And other times people will say, well, gosh, that doesn't seem like enough money. I'd like to pay 2% or more than the 1%. And other times people will say, I don't really like a percentage. I'd rather it be a flat number. I'd rather pay my trustee $10,000 the first year, thinking that's going to be the year of adjustment. It's going to be the most work, and I'll pay them $5,000 each subsequent year. And then I'll always ask clients that want to pay a sum if they want to adjust that figure for inflation, which you certainly can do. So trustee compensation is assumed to be the reasonable compensation under California state law. But when you're doing a trust, you could always change that, because you could pay a trustee nothing. You could pay a trustee an hourly fee, or you could pay a trustee a lump sum. I personally am not a big proponent of paying a trustee an hourly fee, mainly because I feel like that's just adding more work to a trustee that's already basically doing a big job. So trying to, track their time in hours is just more work that they're already doing. So, but that is always a client's choice as to whether they want to opt out of that reasonable compensation. But under California law, it is implied that a trustee would be paid that flat fee on an annual basis for every year that they're acting. And then just something else to talk about is taxes. Every year, the federal government will give each of us something called a federal estate tax exemption, and that is the amount of money that the government allows us to leave tax-free. Every year, that amount usually changes, although there have been a few years where that amount has stayed the same. In 2025, each of us can leave just under $14 million per person tax-free, but only if you're a US resident or citizen. And being a resident counts like a citizen, but you have to be in good standing as a resident. You need to make sure that there's no lapse in your residency. And then I'm sorry, I meant to say that when we die, we also get what's called a forgiveness of capital gains, which is a nice benefit as well. So if I bought a home for $700,000, and at the time of my death, if that house is appreciated to $1.5 million, all that capital gain in that asset gets an adjusted tax basis at the time of my death, as long as my loved ones are inheriting that asset after I die. So when I pass away, if that house has appreciated, when my loved ones inherit that, if they decide that they want to sell that house because they're not going to keep that house, then as long as they sell that house close in time after the time of my death, they don't realize any of that capital gain, because that asset will receive a forgiveness of capital gain as of the date of my death. And that applies to all assets, tangible and liquid and real property. So that, I mean, it's kind of a sad thing to say, but from a tax point of view, when we die, there is a lot of favorable tax treatment, but you don't get that same tax treatment when you make lifetime gifts to your loved ones. So if I had a real property, and if I added my child onto that property while I was alive, and then I died, they don't get that forgiveness of capital gain because it's a lifetime gift. And because I added them onto title while I'm alive, now I've got a gift tax issue as well. Whereas when I die, I can give them $14 million just under $14 million in 2025 tax-free. So it's usually better from a tax point of view for your loved ones to inherit assets after we pass away than to add your loved ones onto title while you're living. And also from a creditor protection point of view, it's better for your loved ones to not be added onto your title. Because I knew a gentleman who wanted to add his adult daughter onto title of his home while he was alive. I advised him that I thought it was better not to do that for a myriad of reasons, but he wanted to add her onto title for his own personal reasons. Unbeknownst to him, he didn't realize that she had some issues with her husband, sadly. And then they filed for a divorce. And then her husband tried claiming that part of his house was community property. And then he ended up getting brought in as a witness to part of their divorce settlement, which was unfortunate. Whereas had he not added her onto title to his property, then his property would have been kept out of that divorce in its entirety. And it would have saved him a lot of time, trouble, and money. So that's just an example. I had another client who she did her trust, and I advised her that when it came to her bank account, she would want to put her bank account into her trust. And then when she went to the bank, the lady at the bank said it would just be easier for her, which actually translates into less paperwork for the person at the bank, to add her daughter onto title of her bank account. And my client called me and asked me if that was something she should do. And I said, please don't do that. Just make the banker do her job. It's better for you to have the account in the name of the trust, because if you lost your capacity, the trust has language where your daughter could then come in and manage that asset for you. And that's important under the law. The nuance between her being a manager of your asset versus an owner of your asset gives you protection if she had any kind of liability. But I guess the lady at the bank was more persuasive. So she ended up putting her daughter on the bank account as a co-owner. And sadly, this poor lady who was like almost 90 years old and didn't have a lot of assets, put her daughter on title as a co-owner of her bank account. And apparently her daughter owed the IRS some monies and back taxes. And when the IRS audited her daughter's social security number, this account came up as being an asset of her daughter's, and the IRS came in and just took like $60,000 out of this lady's bank account and left her with like, I think maybe $12,000 left in this bank account, which was like her whole life savings. So then she calls me in tears, crying, saying, I need you to help me undo this. And sadly, my answer was, I can't help you undo this, because the minute you added her as a co-owner of your asset, her creditors and her liability put your asset at, basically made it vulnerable. So for all those reasons, you just want to be very careful about ever adding anybody as a co-owner of your assets, because any type of liability of theirs affects your asset, whether it's divorce, bankruptcy, a car accident, IRS, back taxes, you name it. So for all of those reasons, because I've had people call me before and say, you know, instead of doing an estate plan, I think I'm just going to add my adult child as a joint tenant, as a joint owner, because that way when I die, I know the asset will avoid probate, and then I don't have to worry about a trust, because that way they'll just be on title. But what they don't understand is when you add them onto title while you're alive, you don't get the forgiveness of capital gain. Because it's a lifetime gift. Now you've got a gift tax issue because you made a gift that exceeds the annual gift amount. Plus, if they have any kind of liability, whether it's the IRS, a divorce, all the things we just talked about, now your asset is at risk. And then you also give up the control, because you don't have a co-manager on that asset like you would with a trust or a trustee, but you have a co-owner. I had a client who sadly, he really wanted to have his son on title to his house, a different client, different scenario. And again, I advised him in my better judgment that that was not a good idea, just to have him inherit the house, but he thought it was better to have his son on title to the house. And sadly, he wanted to sell the house to go into assisted living, and his son flat out refused, because his son didn't want his dad being in assisted living, because the cost of assisted living every month would deplete his inheritance too quickly. So sadly, these are the things that play out in my world of estate planning, that you see a lot of ugly in people. You also see a lot of lovely and good in people, but these are just things to think about when it comes to creating an estate plan, and when it comes to thinking about who you want to put in charge of managing monies. Like I said, I get that question a lot as far as who should be a good successor trustee. Is an automatic conflict of interest if it's family or friends? And so those are the type of things that you want to give some thought to before you make that appointment, or when you're thinking about updating your estate plan. And when it comes to updating your estate plan, you really want to update your estate plan about every 8 to 10 years, because the laws change about every 8 to 10 years. They're very tax specific. One of the things that changed about 10 years ago was it used to be okay for you to name your trust as a beneficiary on your retirement accounts. Now you don't want your trust named as a beneficiary on your on your retirement accounts, because naming the trust triggers additional taxes now that 10, 15 years ago, it didn't trigger. So on your 403Bs, your 401Ks, your IRAs, you want your spouse to be your primary beneficiary for those of you that are married. And for those of you who have children, you want your children to be named by name as your beneficiary. And for those of you that don't have a spouse or children, you want to name your beneficiary by name, whether it's your sister, your brother, your nieces, your nephew, your best friend, your boyfriend, your partner, your significant other, your church, your alumni association. But it's always better to not have the trust on those tax deferred assets, whether it's a retirement account or an annuity, because that's treated the same way. You don't want the trust as the beneficiary because it triggers additional unnecessary taxes that naming individuals, charity, or tax exempt organizations directly avoids. Oh, there's a question about, is it advisable to add your spouse to your bank account, and will the same rules apply as would with your children? So when you're married, I mean, as long as it's a community property asset and not a separate property asset, it would be okay to have your spouse as on your account if it's a joint account. You just want to make sure that you have a pay on death beneficiary. And if you have a trust, the trust would be your pay on death beneficiary. If you don't have a trust, then you want to name your kids as your pay on death beneficiary until you put a trust in place. But it's absolutely okay if you have a bank account to have your spouse as a co-owner of that account. If it's a community property asset, if it's separate property, you don't want your spouse named as a co-owner, but you could have them as a beneficiary on that asset. And then the other thing to think about is when you have an estate plan, and if you haven't updated it in the last 8 to 10 years, you probably want to do an update. There have been some significant changes in the laws as far as adding language about digital assets, cryptocurrency, for those of you that are doing that. Digital assets is giving the powers to have your trustee access your computers, your emails, your cell phones, your cell phone. I said cell phone, sorry. But that digital power is a new power that has evolved over the years as far as social media access and things like that. The tax laws have changed. As I mentioned, you want to update your retirement beneficiaries to not be the trust. For those of you that have refinanced lately, if you do look at your property tax bill, that's one way of looking at how your house is currently titled. If the house is in the trust, then the trust will be on that property tax bill. And that's always a good way of making sure that your house is titled in the trust like it should be, is checking that property tax bill. And honestly, I would just check that every year just for due diligence to make sure. And then just know that when you create this trust, because I made reference that it's like a bucket, as you acquire new assets, you want to open those assets in the name of the trust. So once you have that trust in place, in the future, when you open up a new brokerage account, you're going to open that in the name of the trust. And if you open a new bank account, you're going to open that in the name of the trust. And you can put assets located anywhere in the United States into this California trust. So if you bought a vacation home in Hawaii, you can put that into the name of this California trust. And if you bought a condo in Colorado because you like to ski, you can put that into this California trust. The only thing you can't put into this California trust would be assets located outside of the US borders. And that's because the US doesn't have jurisdiction outside of its borders. So if you bought a vacation home in Canada, then you'd want to talk to an attorney in Canada to deal with that asset. So that's one asset that cannot go into this California trust, would be any asset that's located outside of our US borders. And then for those of you that have that ARAG legal insurance, you do get estate planning coverage through your ARAG legal insurance. And I know I've heard from so many people that they have this insurance and they haven't used it. So for those of you who have it, I would definitely encourage you to use it. It's a great insurance plan. There's a lot of good attorneys that are part of it. We take the ARAG legal insurance. It's super easy to work with. So if you have it, please use it. And for those of you who haven't done an estate plan, I would definitely encourage you to consider doing it for all the reasons we've talked about. Better for you to make these decisions than to leave it to the state of California. And then basically the great question, the best way to start an estate plan would be to, if you have that ARAG legal insurance, you can reach out to them and they can give you a list of attorneys that are either close to your house or work. Like I said, we're part of the ARAG legal insurance. It's a great benefit. We are more than happy to help you with your estate plan if you want to use your insurance through our firm. But basically, when you start an estate plan, I'll tell you our process. What we do is when you contact us, what we do is we send you what we call an estate planning questionnaire. When you do an estate plan, because there are so many really important decisions for you to make, we send you an estate planning questionnaire for you to fill out on your own first. And that's mainly because I used to not do this, and oftentimes I would have people crying in my office because they would be making all these decisions about guardians and high school graduation gifts, and it just would invoke so many emotions that I realized it was just better to let people on their own time have these private discussions first. So what we do is we send you our retainer agreement, which the purpose of the retainer is basically for you to engage us to be your attorney. And if you have the insurance, we bill the insurance. The only thing the insurance doesn't cover are notary fees and the deed fee. So for single people, I think the deed fee is like, I think the notary fee is $175 out of pocket. For married couples, I think the notary fee is like $275, but I'm not sure, but it's not much. And then the deed fee is like $90. So you're basically paying like maybe $350 for an estate plan that if you didn't have insurance is like anywhere from $2,500 to $3,500 for an estate plan. So that insurance is a really good deal. And if you don't have the insurance, they usually do open enrollment in November. So maybe you wait and sign up for the insurance because it definitely saves money and it's such a good deal. But basically, when you do the estate planning questionnaire, it's really going to be a sit down, spend time on it, because you're going to be basically deciding about who you want to be, your trustees, your medical decision makers, beneficiaries, how old you want your beneficiaries to be when they inherit. So basically, you're going to answer all the questions on that questionnaire first. And then we ask you to send us the questionnaire back, and then we schedule our estate planning intake meeting. And basically the purpose of that meeting is we do a meeting together, the attorney and the client, and I go through the questionnaire with you to ask you questions to make sure that we're on the same page before I draft these estate planning documents, because I want to talk through the questions with you. I want to go through all the different scenarios to make sure that I'm writing the estate plan exactly the way that you want it, because all scenarios are different. I want to hear any concerns you might have about your particular family or whether there are any concerns about anything. And then we go through, like I said, all the different planning scenarios, because not all estate plans are the same. And then after that meeting, I draft the estate planning documents. And what I do just to make reviewing them easy, because they are legal documents, they're written for lawyers, they're not very interesting to read, to be honest. So when I draft them, I put everything in black writing that's legal. I put everything in red writing that's client specific, so that when you get the draft, it's real easy to see what's legal versus what's client specific, so that it's just easier to review the draft when you've got the two different colors that's legal versus client specific. And then after I send the clients the draft, it is a first draft. So if they change their mind about anything that we talked about, they're more than welcome to change their mind because it is a first draft. And then we can do a draft review meeting where we can talk through the drafts. I can answer any questions about the documents. I can explain the legal language in the documents. Clients can give me as many changes as they want about the documents. And then eventually we get to a point where they say, everything looks good. I have no other questions. I have no other changes. And then we schedule what we call a signing and notary meeting, which is when the clients come in. That's when I have all the documents tabbed in a nice estate planning binder, so everything's organized. And then the clients sign the documents, we notarize the documents, we scan the documents. We also make these documents into a PDF format, so we have a computer copy, plus we have the originals. And then at that signing meeting, we give clients what we call homework. So that's really the part of the process where we explain, now that these documents exist, this is how you go about updating how all your assets are titled to make sure that there's no possibility of probate. If there's a deed that needs to be prepared, we can help with the deeds. And then basically after that meeting, the clients take their binder, so they keep the original documents. Some law firms want to keep your originals. You don't ever want an attorney to keep your original documents. You want to keep your originals. And yes, we do accept the MetLife legal plan, which is also called Hyatt. And then it asks, are there a certain number of hours that we have to work within the estate plan? So no, I don't think there's any limits with these legal insurance plans as to how many hours it takes. But I will say we do have a 90-day deadline where we ask people to complete the process, because there have been a couple of people, with all due respect, where they just have, it's easy to kick the can or down the road when it comes to just, I'm so busy, I'm gonna start the process, but then put it on the back burner. So we do have a 90-day process where once you start it, we basically ask that you finish the process within 90 days. But that's basically for your benefit, because we want you to finish this process. A lot of law firms don't have that, which really they should, because you want to finish this process. But sometimes people get emotionally caught up in the decisions about guardians and kids, and it's emotional. But you want these documents in place because these documents protect you and your family. So we're really good about trying to get you over the finish line to finish the process, whereas a lot of law firms, with all due respect, they don't care. I care. I want you to do this. When you call me, that's because you care and you want this to be finished, which is what I care about. I want you to finish this process. It's actually a pretty straightforward process. I mean, with all due respect, if there's one thing that's certain about life that we've all been told, it's death and taxes. So why people, and I get it, it's an emotional thing. It's easy to kick the can on this and to not do it, but everybody needs it. And not doing it, actually the whole court process of a conservatorship and the whole court process of a probate for your family is way worse than having these documents in place. And having these documents, the process is so much easier. So doing this and making these decisions and putting the right people in these roles is just such a more loving legacy for your family, that it's just the right thing to do. But anyhow, sometimes my point being, I've had a couple of people, understandably, they just kind of go rogue, and it's an easy thing for some people to go rogue on. So we're very good about trying to get people to stay on path, which sometimes people just need help with. So we do have a 90-day deadline, and that's not meant to be punitive. It's meant to help people finish this process, which your family will be very happy that you finished. But I don't believe that the insurance, I think ARAG used to have like an hourly thing of 8 hours, but I think they got rid of that, which is good. But I find that usually people take about 3 hours of attorney time. And if people are on top of things, we usually can get an estate plan done within 3 to 4 weeks. Actually, it's pretty quick. You just have to make sure that, like, once you start it, just make it a priority, and it's super easy to get done. And to be honest, like, you already probably have in mind who your financial people are, who your medical people are, and who your guardian people are. So it's just a matter of just making it happen. So I think that's it. We basically are out of time. You guys had some really good questions. I hope that this was educational. And for those of you who have an estate plan, I hope you learned some new stuff. And for those of you who don't have an estate plan, I hope that this helped explain what an estate plan is. And that handout pretty much memorializes in writing everything that we talked about today. And I really appreciate your time. And thank you for letting me spend this hour with all of you. I certainly appreciate it.